Right, so our next speaker represents hundreds of thousands of Australians who are victims of bank and financial predators. Michael Sanderson lost his Queensland property due to the predatory lending practices of the banks that led to the 2018 Banking Royal Commission. He's become a tireless advocate for bank victims. As a foundation member of Bank Warriors, the hardy troop of victims wearing bow ties who attend all bank annual general meetings to ask pointed questions of CEOs, Michael is also an advisor of Bank Reform Now. From his experience, Michael has developed a proposal to fix the enormous legal power imbalance between the banks and their victims, which the Citizens Party has adopted as policy, called Lawforce, Equality of Arms for Financial Victims. Please welcome Michael Sanderson.
Thanks, Craig, for that kind introduction. Before I start, I'd like to acknowledge the tireless work of Peter Branson, CEO of Bank Reform Now. At the same time, Peter also operates a full-time medical practice. Also, Craig Caulfield, who refused to call victims who defended themselves when attacked by banks. Rather, they were warriors. Knowing the lack of equity that hundreds of thousands of other financial service provider consumers have experienced in the judicial system, I've developed a solution. Over a period of 7 years, I've had no argument from any political party as to why it wouldn't work or not be able to be implemented. I've been asked by the Citizens Party to explain a financial services Lawforce, the fence at the top of the cliff. On screen are examples of reviews, inquiries, reports, commissions that in one way or another have prosecuted the issue of access to justice. I want to highlight the Senate Standing Committee on Legal and Constitutional Affairs that has inquired into access to justice 3 times this millennium, in 2004, 2009 and 2019. In 2009, the committee stated, "At present, reforming the legal system might appear difficult, onerous and expensive, but the committee believes that ultimately the investment of time, money, will result in significant benefits to all concerned. Otherwise, the committee predicts that within a decade, it will again be inquiring into a failing or failed legal system and asking, why wasn't something done about this 10 years ago? 10 years later, in 2019, the committee was again inquiring into a failing or failed legal system. The system cannot fix the system. The case has been made, the words have been said. Surely it's time for a different approach." If you had to defend yourself in a court, could you? The courts are adversarial. If you had to defend yourself, as I did, you'll find yourself in a metaphorical boxing ring. Your opponent is a heavyweight with a support team and vast resources. You're a lightweight. No, you're not even that. You're a malnourished paraplegic in a wheelchair with no support team, no knowledge and no resources. Also in the ring is a referee, the judge. The question needs to be asked, in allowing such an inequitable competitions to proceed, is the judge, whose paramount duty is the administration of justice, in breach of that principle? What is the principle that underpins the law force? The Australian Federal Attorney General states on his webpage, titled Fair Trial and Fair Hearing, under the heading Equality, what constitutes a fair hearing will require recognition of the interest of the accused, the victim and the community in a criminal trial, and all parties in a civil proceeding. In any event, the procedures followed in the hearing should respect the principle of equality of arms, which requires that all parties to a proceeding must have a reasonable opportunity of presenting their case under conditions that do not advantage them against other parties to the proceedings. The UN Human Rights Committee found a violation of Article 14.1 in a case in which a right of appeal was open to the prosecution, but not the accused. This is a disingenuous motherhood statement. This principle is not upheld by the judicial, legislative, or the administrative sectors. I had the audacity to ask the courts for equality of arms, but was met with excuses, obstruction, interference, and willful blindness as far as the High Court. I formed the opinion that there was no point in asking the system that created the problem for a solution. Better to prescribe one. What is the law force in 3 paragraphs? Paragraph 1. The FSLF is a limited initiative that only applies to financial service provider consumers, small and medium-sized enterprises and farmers that are subject to a legal instrument of an SFP or an entity acting on or for an FSP-initiated legal instrument. It is not and will never be a fix-all solution. This paragraph defines a limit in order to contain argument and complexity. It is important to construct a solution that precisely defines the outer boundaries. The second paragraph. At the commencement of any legal instrument, the FSP will be required to make a non-refundable contribution equivalent to the plaintiff's total internal and external legal budget/costs. Any escalation would require matching contributions from the FSP. The financial service will only be able to recoup their costs from the consumer or SME following an outcome in their favour. This paragraph defines a clear trigger and a payment structure that is proportionate to the action. A law force is self-funding. Little public money would be required. The final paragraph, paragraph 3, it is proposed that the FSP contribution will directly fund a national, and these words are important, permanent, public, independent, specialist financial service law force, which will, by using and working with and funding the contemporary legal aid and community legal aid centres, offer all FSP consumers, SMEs and farmers expert, timely, proportional and equitable legal representation. Australia is a big country and there is a requirement to be able to reach consumers nationally. It makes economic and practical sense for a federal law force to use existing structures as much as possible. A law force gets the equity train on the tracks, making it bigger and wider than proposed at the implementation stage will introduce unworkable complexities that would fracture and destroy the law force before establishment. A law force could be established quickly if there was a political will, as demonstrated by the establishment of the completely new Federal Cyber Security Task Force. We'll go through a couple of some questions and answers here. If the consumer wants to take the FSP to court, will the FSP be required to pay the costs? No, this initiative only applies when an FSP takes any legal action against an FSP consumer, SME or farmer. There may be some issues that could legitimately warrant a defendant to finance a plaintiff, but it would invite every individual with a gripe to litigate. This would render the law force unworkable and would not be fair on FSPs. Will the law force replace internal and external dispute resolution and mediation? Again, no. But because there is equality of arms in the court, it's expected to give added incentive to resolve disputes, therefore increasing their effectiveness. Because the inherent inequity, AFCA, dispute resolution and mediation are rendered not fit for purpose. FSPs use them as weapons. AFCA and FSPs would act differently, knowing that a law force and an equitable court would be the next step. Is it fair to make the FSP pay for the cost of consumers they take to court? It is the FSP and only the FSP that take the consumer to court. FSPs could choose to act more reasonably or use other means to resolve disputes. Unlike indiscriminate levies, the law force only costs FSPs that use the courts and is proportionate to their action. Making the legal process fair and equitable via a law force will protect consumers, assets, businesses and farms. Whoever wins will benefit. The law force is good for both sides. Won't a law force increase costs for FSPs? Potentially. However, if the FSP makes better and fairer use of internal and external dispute resolution, make frugal choices when choosing counsel, combined with greater efficiency in the court process, potentially costs could reduce. Notwithstanding, it will be fairer for the consumer. Consequently, there is expected to be a significant decrease in legacy cases and a saving of considerable cost that those legacy cases represent going forward. Currently, there is no mechanism that governs costs, which results in a lawyer's picnic. The lack of a governor breeds greedy lawyers that do not perform to their potential because of the lack of equity. Will the law force impact on ASIC and APRA? Systemic issues will be identified in an independent and timely manner. This intelligence can be shared with the appropriate regulator, potentially improving their effectiveness and reducing their workload and costs. I don't know if you've heard this, but the recent ASIC review that was a result of John Adams' extensive work demonstrated categorically that ASIC only reviews a small percentage of complaints. The law force would deal with issues upstream, at the top of the cliff, relieving the logjam that ASIC currently receives. This would reduce ASIC's workload, making it more manageable. More importantly, FSP consumers would receive timely, equitable and proportional legal representation at the top of the cliff. How will a law force impact on the contemporary legal aid and community legal aid systems? All legal aid and community legal aid organisations will be able to assist any and all FSP consumers, SMEs and farmers facing legal action in a timely, proportional and equitable manner, knowing that not only funding will be available, but also expert knowledge, support and personnel. The contemporary legal aid sector spends a considerable amount of time and resources begging for funds to enable them to exist. A law force would organically fund FSP complaints proportionate to the workload, reducing the begging and increasing the effectiveness and ensuring their future. How will law force be managed? Law force should have an oversight board that includes federal government, consumer legal aid and community legal aid centre representation, but no financial service provider, farm debt mediation, external dispute resolution, Australian Complaints Authority, or private legal sector representation, so as to avoid white-anting and inappropriate influence. A separate public Federal Bar Association for public legal practitioners should be established to ensure further autonomy and independence. This is important. If an FSP, their representatives or the private legal sector is let anywhere near management of a law force, self-interest will render it not fit for purpose very quickly. If one needs examples, look at all those inquiries that went nowhere. What about the financial self-regulation? Then there's the bank-approved Clayton's Banking Royal Commission and the Australian Bankers Association eroded banking code of practice. There will be enough interference to contend with due to the powerful FSP political lobby and regulatory captured politicians. Nice picture. Who would lead a law force? If a law force is run by a political or industry toady, it would be sabotaged from within. If only we could resurrect Elliot Ness, an incorruptible crime fighter, and his team of agents have handpicked for their incorruptibility. They were nicknamed the Untouchables. If I was to nominate somebody to lead a law force, I would nominate Professor Andrew Schmulo. I could only imagine Andrew, with his ethics, knowledge and depth of experience, leading a national law force that has the collective budget of all FSPs. Let us not forget the law force only establishes something that should already exist. That is access to justice and equality of arms. The law force will lift judicial standards and result in better precedent and law. As a bonus, the law force will spawn judges that come from the force, not just the dark side of law. See where I'm going with this? In closing, I would like to say, if sometime in the future you were pursued by a financial service provider, may the force be with you. I would like to make a couple of comments and observations off topic. I'll give you the next slide. You like this one. This slide features a couple of old blokes, Leo and Con. To guide my thinking, I've adopted a couple of their insightful perspectives. We collectively reap what we collectively sow. The collective us have not been advanced by the political crop rotation of red, then blue, then red, then blue. The 36-year-old Citizens Party, over many years, among many other things, has actively and aggressively supported Australia Post and a public bank using postal outlets as their agents. I believe there is a unique window this election cycle for licensed post offices to flex their collective muscle. LPOs could not only assure their survival and viability, but also grow their respective communities. LPOs have a large footprint and therefore a large boot. They could collectively choose to use it by supporting and working with the Australian Citizens Party this election. Isn't it time to take a leap of faith and sow a new crop? Thank you.